California landlords. A new California Court of Appeals decision has changed the standard of how 3-day notices for non-payment of rent need to be issued and calls out some common mistakes landlords make. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, a new Court of Appeals decision from the Court of Appeals Appellate Court that covers Los Angeles County came out with a case, Eshland versus Cepeda. It's came out on June 26 this year. It's case number B340941 if you want to look it up. Long story short, it was an appeal that was taken from an unlawful detainer or eviction case on for non-payment of rent, and the Court of Appeals called out this landlord's 3-day notice for several different reasons. In this case, the landlord had not listed that not listed on a 3-day notice that the 3-day notice period didn't cover weekends and judicial holidays, and the court imposed a new standard stating that the landlord needed to provide an ordinary tenant with when the 3-day notice period started. Okay, that's not in the Code of Civil Procedure, but it appears that the court made basically new law, a requirement now that landlords at least provide the date when the 3-day notice period starts. We got a news blast from the California Apartment Association. I read the case as well, and it appears that that's the major change here. I'm going to read what it says here. The notice did not state when the notice period commenced or ended, nor did it inform Cepeda, the tenant, that the 3-day notice period excluded weekends and judicial holidays. So from that reading, it appears that we might now have to put the date of service on the notice itself to advise the tenant of what the 3-day period starts. Okay. This landlord also got called out for listing where rent could be paid. He put the tenant's rental address. You never could have done that. The law says under Code of Civil Procedure 1161 subdivision 2 that you have to put the person to where rent needs to be paid, their name, address, and telephone number. Okay. And I see that common mistake a lot with landlords. They'll put the rental address. Why? Because they go pick up the rent. So that's a no-no. Always been telling landlords not to do that. And this decision actually notates that's not acceptable. Okay. So landlords, stop doing that. If you're doing that, the other issue that, the Court of Appeals notated too on this particular landlord's notice, it did not state what would happen. Like the tenant would be subject to immediate eviction. Okay. Most 3-day notices that are, prepared by, reputable entities, will basically tell a tenant that, the lease rental agreement will be forfeited and legal proceedings will be commenced. Okay. Now, there's a gray area here. There's a question about, okay, this ordinary tenant standard, again, that the court mentions, do you have to put that the tenant will be subject to unlawful detainer proceedings, aka an eviction? What would an ordinary tenant understand? Okay. And that's kind of, the court never really cleared that up. But what I would interpret that to be is you got to put, a tenant on notice that you're going to start an eviction. Okay. In plain English, we're modifying our notices to basically state that if you fail to move out or you fail to pay the rent, demanded on the notice, you will be subject to unlawful detainer, in parentheses, eviction proceedings. Okay. I don't know how much clearer we can make that, but the problem with these type of decisions are they don't really clear up what the standard is they cause confusion and so forth. So California landlords, you're going to have fun in the next couple of weeks here. I know CAA, the Apartment Association, is modifying their notices. So stay tuned for updates. Put your comments down below. I'll see you in the next video. Okay. See ya.